Stolen vehicle report, license and registration.
Officer, why was I stopped?
I'm not debating with you. Hand over your documents now.
What's the report number?
You're making this harder than it needs to be.
I have a right to know why I'm being detained.
I'm asking a simple legal question.
The red and blue lights exploded in her mirror just 2 miles from home. And in less than 10 minutes, a routine drive would turn into the most expensive mistake a Texas sheriff had ever made. Before I continue, tell me in the comments where you're watching from. And if you believe in justice and accountability, make sure you subscribe right now, because this story only gets more intense from here. It was late afternoon in Houston, Texas. 42-year-old Judge Alana Reed, a respected federal judge, was driving her midnight blue Lexus through a quiet suburban stretch. She had not been speeding. She had not crossed any lines. Her record was clean. Her day had been long, filled with classified briefings tied to a sensitive federal investigation. Then the patrol lights came on behind her. Sheriff Harold Whitaker of Kendall County stepped out of his cruiser with slow, heavy steps. His jaw was tight. His hand hovered near his weapon. He walked to her window like he had already decided she was guilty of something. Stolen vehicle report. License and registration. Judge Reed kept both hands on the wheel. Officer, why was I stopped? I'm not debating with you. Hand over your documents. Now, what's the report number? You're making this harder than it needs to be. I have a right to know why I'm being detained. I'm asking a simple legal question. Judge Reed slowly reached for her purse and pulled out her Texas driver's license along with her federal judicial credentials. The gold seal of the United States District Court was visible. Her title was clear, United States District Judge. Whitaker glanced at it for barely 4 seconds. These could be fake. Step out of the vehicle. That was the moment she understood. This was not about a stolen car. She stepped out calmly. A second deputy, Officer Grant Dawson, arrived shortly after. Whitaker announced loudly over his radio that she was suspicious and unable to explain ownership of a luxury vehicle. That was false. She had explained nothing because she had not been asked. Her dash camera was recording. The nearby bank's security cameras were recording. And a man across the street, eating lunch in his truck, had started recording on his phone. Whitaker opened her driver's side door. On the passenger seat sat her black leather briefcase stamped with the federal court seal. A large envelope inside carried bold red lettering, classified, national security. Do not open that, Judge Reed said firmly. Those documents are federally protected. You do not have clearance. Whitaker ignored her. He forced the lock. The leather tore. Inside were sealed federal files, including an ongoing investigation from the Department of Justice. Dawson hesitated. Sheriff, maybe we should call. Photograph everything, Whitaker ordered. He pulled out his personal phone and started snapping pictures. Page after page. Names, evidence, protected identities. Dawson followed his lead. 70 pages total. Judge Reed stood there in handcuffs, watching 2 local officers photograph classified federal documents without authorization. You are committing a federal crime, she said clearly. You are accessing classified information without clearance. Whitaker smirked. You should have just cooperated. What he did not know was that one of those files contained details about a federal investigation into illegal database access and the sale of confidential information across multiple counties. On page 7 was a name. Sheriff Harold Whitaker. He had just photographed evidence of the investigation into himself. Minutes later, he tightened the cuffs on her wrists and placed her in the back of his patrol car. She did not shout. She did not resist. She memorized everything. Time of arrest, 4:21 p.m. Location, Westheimer Road. Witnesses present. Backup officer involved. Personal phones used to photograph classified material. Every detail locked into her mind. Back at the federal courthouse, her assistant, Daniel Brooks, noticed she had missed her 4 o'clock p.m. security check-in. That had never happened before. By 4:15 p.m., federal protocol was activated. Deputy U.S. Marshal Karen Holt traced her last phone signal to the bank parking lot. Within minutes, federal agents were dispatched. At 4:31 p.m., they found her Lexus sitting alone. Bank security footage was reviewed on the spot. They saw everything: the stop, the credentials, the forced search, the photographs, the arrest. Deputy Holt immediately called Kendall County Sheriff's Department. "You have a sitting United States District Judge in custody," she said coldly. "Federal agents are on the way. Do not move her." Inside the county holding area, Captain Liam Briggs approached the cell where Judge Reed sat upright, calm, and composed. "Judge Reed, where are the documents?" she asked. "They were photographed. Uploaded." Briggs swallowed. "Yes." "All of them?" "Yes." She stood slowly. "Then your sheriff has just handed federal prosecutors the cleanest obstruction case they will ever see." Briggs felt the weight of those words settle over him. Judge Reed continued, steady and precise. "He profiled the wrong person, and he destroyed himself doing it." Outside, sirens grew louder. Federal vehicles were arriving, and Sheriff Harold Whitaker had no idea that his career, his freedom, and his department were about to collapse because of one traffic stop that should have never happened. By the time the federal vehicles pulled into the sheriff's department parking lot, the traffic stop was no longer a local issue. It was a full federal crisis with national security implications. 7 federal agents walked through the front doors with calm authority. No shouting, no rushing, just control. Deputy U.S. Marshal Karen Holt led the team. Her badge was visible. Her tone was firm. Sheriff Harold Whitaker stepped out of his office, confused but trying not to show it. "What's this about?" he asked. Holt looked him straight in the eyes. "You arrested a United States District Judge. You accessed classified federal documents. You photographed them with a personal device. You uploaded them to private cloud storage. That's what this is about." Whitaker's face stiffened. She was obstructing an investigation. "What investigation?" Holt asked. "A stolen vehicle report. Provide the report number." There was silence. Dispatch records were pulled immediately. No stolen Lexus had been reported that day. None matching her plate. None matching her vehicle description. The claim was false. Whitaker's breathing changed slightly. He tried to shift focus. She was uncooperative. Judge Alana Reed stepped forward from behind Holt. The handcuff marks were still visible on her wrists. "I asked for the report number." "That is not obstruction," she said evenly. The room felt smaller. Federal agents confiscated both Whitaker's and Officer Grant Dawson's phones on the spot. Forensic technicians began extraction procedures immediately. Every image, every message, every cloud upload. Within 30 minutes, confirmation came in. 70 images of classified federal documents had been successfully uploaded to 2 separate cloud storage accounts. Time-stamped. GPS tagged. Synced across backup servers. Whitaker looked at Dawson, then back at Holt. "We didn't share them." "That doesn't matter," Holt replied. "You accessed them." Judge Reed added calmly, "Unauthorized possession alone qualifies." The next blow landed harder. Federal investigators informed Whitaker that one of the photographed documents was part of an ongoing Department of Justice investigation into illegal database access across several counties. Whitaker blinked. "What?" Holt didn't soften it. "You photographed your own indictment." The silence that followed felt heavy. Within 2 hours, federal search warrants were executed at Whitaker's home, his office, and the homes of 5 deputies connected to him. Computers were seized, external drives collected, financial records subpoenaed. Meanwhile, Judge Reed was escorted back to the federal courthouse under protection detail. By 8:00 p.m., The Department of Justice had opened 3 separate investigations: civil rights violations, obstruction of federal proceedings, unauthorized access to classified information. The following morning, digital forensic results began surfacing. Whitaker's phone contained far more than the 70 photos. There were text messages, years of them. Messages between Whitaker and several deputies discussing traffic stop targets. References to certain neighborhoods. Comments about pulling over luxury cars that don't match the driver. Direct racial slurs. Jokes about arrest quotas. The data did not stop there. Financial records showed deposits over 15 years totaling $380,000 from private investigators, bail bonds companies, and third-party entities. Each deposit closely followed unauthorized law enforcement database searches. 1,912 unauthorized queries. Names of private citizens, business owners, journalists, political figures, celebrities, information that had been sold. The pattern was clear. Sheriff Whitaker had built a quiet side business selling confidential database information, and the federal judge he tried to intimidate had unknowingly been reviewing the final stages of that very investigation the day he stopped her. 3 days after the arrest, Whitaker was placed on administrative leave. 5 days later, he was formally indicted by a federal grand jury. 47 counts. The charges included deprivation of rights under color of law, obstruction of justice, unauthorized access to classified materials, wire fraud, conspiracy, computer fraud. Officer Dawson was charged as well, though with fewer counts. The news broke nationally. Headlines across Texas read, "Texas Sheriff indicted after arresting federal judge." Public reaction was intense. Civil rights organizations demanded accountability. Community members came forward with complaints dating back years. Within 2 weeks, 29 individuals had filed formal statements describing similar stops. Same aggressive tone, same baseless claims, same humiliation. Judge Reed remained silent publicly. Privately, she reviewed every piece of evidence carefully. She did not rush. She did not celebrate. She understood something important. The strongest cases are built slowly and methodically. One evening, during a private deposition session, Whitaker's attorney attempted to suggest that Judge Reed had escalated the situation. That was when the most intense exchange of the entire investigation occurred. Whitaker spoke directly to her across the table. "You could have just handed over your documents without arguing." Judge Reed's eyes did not move from his. "I did hand over my documents. You questioned me. I asked for a report number. You challenged my authority. You fabricated a crime." Whitaker leaned forward. "You think this is about race?" She answered without emotion. "Your stop history is 89% minority drivers in a county that is 72% white. That is not coincidence." He clenched his jaw. "You don't know what it's like out there." She held his stare. "I know exactly what it's like. I've seen your text messages." Silence filled the room. Whitaker leaned back. That exchange would later be quoted in court transcripts. As federal prosecutors prepared their case, more evidence surfaced. Internal complaints against Whitaker had been filed 52 times over 15 years. Every single one had been dismissed without proper review. Supervisors had ignored statistical red flags. Early intervention systems had flagged him as an extreme outlier twice. Nothing had been done. This was no longer about one arrest. It was about systemic failure. The trial date was set for 11 months later. Sheriff Harold Whitaker was released on bond pending trial, but his badge had been taken. His authority stripped. His department under federal monitoring. Judge Reed returned to the bench within days. She wore her judicial robe without hesitation. She continued presiding over federal cases with the same steady voice. But the case against Whitaker was building into something historic. The Department of Justice had assigned senior prosecutors. The evidence was overwhelming, and the entire country was watching. The federal courtroom in Houston was silent the morning Sheriff Harold Whitaker walked in as a defendant instead of a lawman. The same man who once stood behind a badge now stood beside a defense attorney. Judge Alana Reed was not in the room. To avoid conflict, the case was assigned to Judge Victor Langston from another district. Known for strict rulings and zero tolerance for corruption, he made one thing clear before proceedings began. This courtroom will deal in facts, not emotion. The prosecution wasted no time. They started with video. 5 synchronized angles from the bank parking lot played on large screens. Clear footage showed Judge Reed's vehicle pulling in calmly, her hands visible, her posture compliant. Then Whitaker's voice filled the courtroom. Stolen vehicle report. License and registration. The prosecutor paused the video. Provide the report number, she had asked. The footage resumed. There was no report number. The jury watched Whitaker examine her federal credentials for 4 seconds before dismissing them. These could be fake. Step out. Gasps were quiet but present. The forced opening of the briefcase followed. The tearing leather sound echoed through the speakers. Then came the photographs. Click, 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 70 times. The prosecution zoomed into the footage, showing Whitaker holding pages marked classified, national security. The defense objected repeatedly. The judge overruled each time. Next came the digital forensic experts. They explained metadata in simple terms. Each photo records time, location, and device ID automatically. A large screen displayed the timestamps. 4:11, 3 p.m. 4:11, 8 p.m. 4:11, 14 p.m. The uploads occurred seconds later. Cloud backup confirmed. Irreversible. Then the prosecutor revealed the most damaging document. Page 7 of the DOJ investigation. Sheriff Harold Whitaker, named as the primary subject in a federal corruption probe. A juror visibly leaned back in disbelief. The prosecution moved into financial evidence. Bank records traced $380,000 in deposits across 15 years. Dates aligned almost perfectly with unauthorized database searches. The database logs were presented next. 1,912 unauthorized queries. Names of private citizens, business competitors, journalists, individuals who had never been suspects in any crime. The pattern was obvious. Sell information, get paid. The prosecution then introduced statistical analysis. A data expert explained clearly. In a county that is 72% white, Sheriff Whitaker's stop rate was 89% minority drivers. The expert paused. That percentage cannot occur naturally without intentional targeting. The courtroom was heavy. Then came the text messages. They were read slowly. Messages about luxury cars that don't match the driver. Comments mocking people pulled over. Slurs. Celebrations after arrests. The defense argued they were jokes. The prosecutor responded calmly. Jokes repeated over 8 years are patterns. The most powerful moment came when Judge Reed took the stand. She wore a simple navy suit. No robe. No jewelry beyond small earrings. Just facts. She described the stop without exaggeration. I asked for a report number. She described presenting her credentials. I informed him I was a federal judge. She described the search. I denied consent clearly. The defense attorney tried to shift blame. Judge Reed, is it possible your tone escalated the situation? Her answer was calm. My tone was the same tone I use in court. Did you challenge his authority? I questioned a fabricated report. Did you refuse to comply? I complied with every lawful order. The attorney pressed harder. Do you believe this stop was racially motivated? She looked directly at the jury. Based on the statistical evidence and his documented patterns, yes. No raised voice. No anger. Just certainty. 29 additional victims testified over the next week. A mother who lost her job after a false arrest appeared on her record. A small business owner whose reputation was damaged. A college student who had charges dismissed months later but lost a scholarship in the process. Each story followed the same pattern. Pretext. Aggression. No probable cause. Judge Langston instructed the jury carefully on the law. Deprivation of rights under color of law. Unauthorized access to classified information. Wire fraud. Conspiracy. Obstruction. After 4 weeks, closing arguments were delivered. The prosecutor ended simply. This case is about abuse of power. It is about a badge used as a weapon. The defense argued Whitaker had made mistakes, not crimes. The jury left to deliberate. 6 hours later, they returned. The courtroom stood. Count 1. Guilty. Count 2. Guilty. Count 3. Guilty. The verdict continued. All 47 counts. Guilty. Whitaker's face went pale. Officer Dawson was found guilty on multiple counts as well, though fewer. Sentencing was scheduled 6 weeks later. At sentencing, the prosecution presented victim impact statements from 37 individuals. Lives disrupted. Careers damaged. Trust broken. Judge Langston spoke for nearly 20 minutes before issuing the sentence. Law enforcement authority is not a shield for corruption. It is a responsibility. When abused, the damage extends beyond individuals. It damages public trust. He reviewed the classified document breach. He reviewed the financial scheme. He reviewed the racial targeting. Then he delivered the sentence. 52 years in federal prison. No parole. No early release. Whitaker's knees nearly buckled. Officer Dawson received 21 years. 4 additional deputies received sentences between 8 and 14 years. The department supervisor received 10 years for deliberate indifference. The courtroom was silent as the reality settled in. One traffic stop had exposed 15 years of corruption. But the story was not over. The civil lawsuit was about to begin, and the financial consequences would shake the county to its core. If the criminal trial destroyed Sheriff Harold Whitaker's freedom, the civil trial was about to destroy everything his department had built around him. Judge Alana Reed did not rush to file her lawsuit. She waited until the criminal convictions were secured. Then she filed a federal civil rights action against Kendall County and its sheriff's department. The claims were clear and simple. False arrest, civil rights violations, emotional distress, abuse of authority, failure to supervise. But this case was not just about one arrest. It was about a system that had ignored warning signs for 15 years. 3 months before trial, Kendall County offered a settlement. $4.2 million, with a confidentiality clause. No public statements. No admission of wrongdoing. Judge Reed rejected it immediately. "This is not about silence," she said privately to her legal team. "It is about accountability." The civil trial began in a packed courtroom. This time, it was not about prison time. It was about institutional failure. The plaintiff's attorneys presented evidence that was even more disturbing than what the criminal jury had seen. Internal affairs reports showed 52 formal complaints against Whitaker over 15 years. Every complaint had been dismissed. Some had not even been fully investigated. Early warning software had flagged him twice for disproportionate stops of minority drivers. Supervisors ignored it. One former internal investigator testified that he had recommended disciplinary review years earlier. He was transferred 2 months later. Emails were displayed on large screens. One supervisor had written, "He gets results. Don't micromanage." Those words hung heavy in the courtroom. Then came the financial experts. They calculated damages not only for Judge Reed's arrest, but for the long-term institutional harm and constitutional violations. The plaintiff's lead attorney addressed the jury directly. When a department ignores patterns this obvious, it sends a message. That message is that rights are optional. Judge Reed testified again, but this time the focus was different. "How did the arrest affect you personally?" her attorney asked. She answered honestly. I serve the Constitution every day. Being handcuffed without cause was not just personal humiliation. It was an attack on the rule of law. Her voice did not shake, but the impact was clear. The defense attempted to argue that the department could not predict Whitaker's criminal conduct. The plaintiff's team responded with documented proof that they had been warned repeatedly. Statistical charts, complaint logs, ignored alerts. The jury did not need long. 4 weeks of testimony ended with closing arguments. The plaintiff's attorney ended simply. This is about power without oversight, and what happens when nobody stops it. The jury deliberated for less than a full day. When they returned, the courtroom stood. The foreperson read the numbers slowly. Compensatory damages, $10 million. Punitive damages, $25 million. Total, $35 million. The largest civil rights verdict in Texas state history. The courtroom was silent before quiet reactions spread. Some jurors wiped tears. County officials looked stunned. Reporters rushed outside to file breaking headlines. $35 million. But the most powerful moment came 3 weeks later. Judge Reed held a press conference on the steps of the federal courthouse. Cameras lined the front lawn. She stepped to the podium calmly. She spoke clearly. I did not pursue this case for personal wealth. I pursued it because unchecked authority harms communities. Then she made the announcement that stunned the nation. Every dollar of the $35 million would be donated. $12 million to the National Police Accountability Project. $10 million to the NAACP Legal Defense Fund. $8 million to the Innocence Project. $5 million to community legal aid organizations across Texas. She kept nothing. Not $1. The message was clear. This was never about revenge. It was about reform. Within months, the Department of Justice imposed a federal consent decree on Kendall County. 10 years of federal oversight. Mandatory body cameras with independent storage. Quarterly public reports on traffic stops broken down by race. An independent civilian review board with subpoena power. Early intervention systems that could not be ignored. Mandatory bias and constitutional rights training designed by civil rights experts. The changes were structural and permanent. 3 years later, measurable results were reported. Traffic stop racial disparities dropped sharply. Complaint response time improved. Community trust surveys showed significant improvement. The foundation created in Judge Reed's name began funding wrongful conviction reviews. 22 individuals were exonerated in the first 3 years. Hundreds received legal representation who otherwise could not afford it. What began as one traffic stop had triggered statewide reform. Meanwhile, Sheriff Harold Whitaker sat in federal prison serving a 52-year sentence. No badge, no authority, no control. Judge Reed returned to her bench daily. Same calm voice, same steady presence. She continued presiding over cases involving corruption, civil rights, and national security. The final image could not be more different. One person abused power and lost everything. The other endured humiliation, stayed composed, and used the system to enforce accountability. Justice did not move fast, but it moved with weight, and it left a permanent mark. If this story showed you how evidence and composure can dismantle corruption, make sure you subscribe and share it. And before you go, answer this honestly. Do you believe systemic reform only happens when someone refuses to stay silent?